here. Okay, folks, welcome back after 3 weeks. As you all know, I was gone for a week, and I tried to broadcast from home last week, and because it's only a tiny little file, a Java file that's 9 kilobytes in size, it blocked me from broadcasting at home, which is funny because I've done it many times before. So those of you who missed one or the other, the last 3 lectures because I was out of town on and off, remember, they are on the archive section of our website. You know, if you look at our web page, the tools on the left side of our MyCR page, class archives, you can click on there. In fact, when I finally got last week's lecture prepared and delivered, within about 45 seconds, it was already archived by the CCC Confer system. I actually clicked on it, and yep, it was all there. So even though there wasn't class participation, when we deal with exam 3 will definitely be, exam 3 will be posted, and it'll be based on some of the material we covered the last 3-4 weeks. Even though you didn't have the regular way of participating, it's still going to be covered information and fair game on the test. So please, if you haven't done so, folks, do go on the archives and watch those lectures. I'm actually going to go a little bit out of my way to make sure that some of the material there, I don't always do that, but is covered because there's a lot of important information. I don't always pick stuff up from the book. So, Mr. Creel, is that class related? It could be. Well, why don't you put it away unless it is. Okay. Anyways, let's get started. So just a couple of preliminaries, and it's great to be back. What we're going to do today and next week as well, but particularly today with Chapter 12, it's our next to last chapter. I was telling some of the folks in class that this slide presentation was originally 90 slides long. It covered not even the tip of the iceberg of federal crimes, but it covered a lot of them. I've really whittled it down considerably, and my goal today is to do 2 things. Number 1, to talk a little bit about how the feds handle preliminaries in criminal cases a bit different, such as the insanity defense, juvenile crime, accessories and principles of the crime. The feds handle some of that a bit differently. I'd like to talk about that, number 1. And the second thing I'll do in today's class is we'll just cover some selected crimes. Some of them that have particular interest in the federal system, such as white-collar crime and things of that nature. If anybody hasn't had a chance to look up CPC 418, it's not exactly my stupid crime of the week, but it's a little unnecessary. CPC 418 provides that if you have been evicted from a place and you come back and you're not wanted, that's a separate crime. It's a misdemeanor. Well, it kind of sounds to me like trespass. It's a trespass. So who knows why the state of California put that in there, but yet I guess it's the Lawyers Relief Act of 1939 or something like that, why they put additional statutes in, but go figure. So one other wonderful example of our penal code. Anyways, interesting issue that came up because this week's discussion question deals with bank robbery, which can be a state crime, of course, as well as a federal crime. But in discussion question 14 that I just posted this morning, we're dealing specifically with the federal bank robbery statute, 18 U.S.C. 2113. And I'll leave it to you to discuss, but there's a news story today in CNN. This Wyoming reporter may be forced to testify about a bank robbery suspect she interviewed. So after the robbery took place, this news reporter in Wyoming, a newspaper reporter, interviewed at length the suspect. And so the government wants her notes, and they want to subpoena her. And so there's a little bit of an issue, but before I get to that, why, in this case, a judge is thinking of holding her in contempt in district court in Wyoming, federal district court. Why this case even get to the feds? This is a little bank in Lander, Wyoming, population 10,000, Podunk, USA, a state-run, state and federally chartered bank. So how did the feds get into this bank robbery case? Wyoming law provides you don't point a shotgun at somebody and rob them. That's as much wrong under state law as it is federal law. So does anybody know why the feds are involved in this? This is a federal court case.
Bank federally insured?
Yeah. The bank is federally insured and follows some regulations of the Federal Reserve System. And if that isn't enough, clearly under the Interstate Commerce Clause, bank robberies and crimes against financial institutions have a most definite impact on interstate commerce. What's really more interesting with this particular case that came over the news wire today is the fact that this reporter, Wyoming doesn't have a shield law. I think you remember, AJ, you took 6, right? Remember we talked about shield laws, newspaper privileges? Yeah. In California, we have a fairly strong law that says if this bank robbery happened in California, in Eureka, say Bank of America, or Coast Central, and the Eureka Substandard, they're half a newspaper, but I'm not going to go into that. But if the reporter had interviewed a suspect, California law is fairly good at protecting the reporter from disclosing her source and subpoenaing her notes. Why? And why do we protect reporters' notes from disclosure? Anybody? Why do we protect? Why don't we let the feds or the state criminal justice people get at the news notes? What do you think, Mr. Creela? How come we're not going to let them have it in most states, even though they confess to a crime? Well, give it your best shot.
Why don't we give them the notes?
Well, no. Why would the newspaper say, no, we're not going to give you the notes and we don't have to? And why don't we let the feds or the states get evidence of a crime from a newspaper reporter, which would be great to use at a trial?
Journalistic ethics.
It's partly journalistic ethics. Why else? Anybody out there?
Their stuff.
Well, of course, well, it's my stuff, but if somebody talks to me and I'm not a lawyer, they can subpoena me.
A lot of that is because if they have a source and they find out that they're going to get that the newspaper's going to tell the cops, they're likely not going to get information.
Good. It's analogous to the attorney-client privilege of the trust issue. The First Amendment has freedom of the press in it, and the framers of the Constitution, the Bill of Rights, clearly, and the Congress clearly are in favor of news gathering and news information as part of a democracy. For instance, we can't intelligently vote on anything and participate in running our country unless we get reasonably informed opinions on what's going on. It's the newspapers and press, radio, TV that help us form our opinions, that help give us sometimes reliable information. So if news reporters, for instance, in criminal justice, if they couldn't get information that anonymous sources gave them that might be credible, then we're not going to get reliable information because nobody would talk to them. For them to really tell the public what's going on. The cops are closed-mouthed for obvious reasons, so sometimes it takes other sources to get information. And it's also a question of news ethics, a journalism code of ethics. So I thought that was a rather interesting case as far as bank robbery, because it just came up this morning while I was putting the finishing touches on this lecture. So we're going to move fairly quickly on a lot of this material. So let's get going. Okay, federal crimes are enacted. No great surprise. They're enacted by the United States Congress. It's the legislative branch of the national government, much like the California Penal Code is enacted by the California legislature, i.e. the lawmaking branch of our state government. And Congress is the lawmaking branch of the national government. One big difference coming up right now is common law does not apply in the federal system. There is no such thing as federal common law, so it's purely statutory, which means if the law isn't found in the Title 18 United States Code or some other place in the federal codes, it's not a crime. End of story. That's not always true, as we talked about earlier, in state law, because sometimes state law, common law, can fill in the gaps. It so happens California is one of those states that's much like the federal system that says, I think it was way back in 1879 in our current Constitution of California that expressly states if it's not essentially in the penal code or one of the other California 28 codes, it's not a crime. While we use common law to fill in the blanks in California, the feds, there's an absolute disclaimer, if you will, of common law. It just doesn't exist. So when Congress, when the courts try and determine what the law means, they basically have to look very heavily to Congress as far as what was meant when they passed it. So how do the courts figure out what Congress meant? And these days it's relatively easy because a major piece of legislation like the Patriot Act and terrorism, there's often hearings and congressmen and committees issue reports on why they passed the law. So very important concept. Difference number one, there is no federal common law. Difference number two, the federal government's powers are strictly enumerated under Article 1, Section 8 of the Constitution, most of the federal penal code, found in Title 18 of the United States Code. The U.S. Code has 50 different titles, and crime and punishments fits under Title 18. I think it goes from administration of the government, Article 1, I can't remember what the 50th title is, to the code. But anyways, unlike state law, and this is a critical difference, and I'll probably cover this on the exam, if a prosecutor wants to bring a case against someone and the defendant challenges it as unconstitutional, not because their Miranda rights are violated, not because the cop should have had a warrant, a search warrant, so it's not a search and seizure issue, it's not a Miranda issue. But if a federal criminal defendant claims that the law is simply unconstitutional, you can't pull that in state court, really. But in a federal court, if the federal court looks at the United States Constitution, they look at this crime that the defendant's accused of, and the federal court can't find anywhere in the Constitution, in Article 1, Section 8, that gives Congress the power to make this criminal law, out goes the criminal case, and the defendant gets to walk out of the courtroom. That's because under our system of government, I know Mr. Nova and Mr. Boyer, both currently taking poli-sci 10, understand this concept of limited or enumerated powers in the criminal justice system, elsewhere too, at the federal level. What this simply means is that the feds cannot pass a criminal statute that is Congress unless that power is found in the United States Constitution. It's illegal. It's unconstitutional. We're not talking here, folks, about Bill of Rights, search and seizure, Miranda, right to a lawyer. That stuff is the procedural law that we talked about in chapters 1 and 2. What we're talking about here is the substantive criminal law. What behavior is a crime? Congress can absolutely not define any behavior a crime unless the power to define that behavior as a crime is found somewhere in the Constitution. These are the 5 leading examples. I didn't quote the specific passage in the Constitution, but pay heed to this, because here, these are the 5 bases, and I'll go through them very quickly, upon which the federal criminal justice system rests, that is, the power to define crimes. Number 1, interstate commerce. If bank robbery, robbing banks, for instance, that affects interstate commerce. Kidnapping somebody and driving them across state lines, or walking them across state lines, like the Lindbergh case, if some of the crime happens in another state, that's an interstate commerce issue. Sending telemarketing fraud, that affects interstate commerce. You kind of get the idea. If I go to anybody here ever been to the Clark Street Post Office? No one's ever been there? You ever want to haul up and sock some of those people that are so damn slow sometimes? This is being recorded, so I guess I better keep the word George Carlin or damn out of this. Anyways, no disrespect to postal employees, but if I'm pissed off and I don't like the service I'm getting at the Clark Street station, and I knock and hit them in the noggin, the window clerk, because they're being slow or maybe mouthy or something like that, then, well, sounds like the EPD ought to be called and kind of take care of this. That sounds like simple assault to me. It would likely be a federal case, and the feds have statutes prohibiting assaulting federal employees. It's Congress. In this case, it's easy. The Constitution gives Congress the right to establish post offices. It's expressly mentioned. So any activity that deals with defrauding a post office, stealing its property, peeing in the lobby, something like that. In fact, when I was a county prosecutor, the post office was right across the street from the courthouse, I remember, and they were having a rash of that. well, it wouldn't be worth prosecuting some homeless person for peeing in the lobby, but they ended up having to lock the doors. I don't know if they put surveillance cameras in there, but I mean, there was no other defacement of the premises. I think that's happened here a couple of times. But what's that?
Not too long ago.
Yeah. And the feds, had they chose, the FBI could get involved and they could prosecute if they caught the guy for defacing or urinating, indecent exposure, what have you, at a government facility. Crimes on federal public lands. A real quick example, there was a cold civil rights, a murder case where the state of Mississippi in the 60s, the Bobby Seale case of Ku Kluxers, they cruelly beat up and killed this black kid in like 1964. And in 1964 Mississippi, no white jury is going to convict a white person against killing a black. It just ain't going to happen, and never happened, even though the murder was out there for everybody to see. Well, it so happened, fortunately, for the family of this young man and justice in and of itself, the federal government was able to prosecute him. Why? It so happens they dumped the body on a national forest, in a national forest site in Mississippi. So the federal government, once they got, and the FBI did an investigation in 64, once they got all the FBI's material, rounded up some surviving witnesses, the U.S. attorney down there was able to actually prosecute. And Mr. Seale, the sheriff's deputy, who was one of the key players in this homicide, he actually went to prison. He was 79 years old. He went to prison. I think he lived 5 more years and died like last year. But justice was finally delivered, albeit 30, 40 years too late. Crimes against federal property. I kind of addressed it in the third bullet item, real or personal. So stealing stuff from the mails, defrauding the government of contractors. If they have a contract, say, with the Department of Defense, and they don't deliver as advertised, or they're cheating, then, of course, those are federal crimes, defrauding the United States, or theft of government property. Some of you live in Eureka, you know we have the armory nearby, and they have the red, white, and blue little placards on the chain link fence, all that military hardware and gear, the equipment. They mentioned something like it's a crime, no trespassing, so if the FBI caught somebody climbing over the fence and tampering with property, that's a federal crime. Even though EPD could prosecute because it's in the city of Eureka and the state, the federal government would have authority, but only because it happens to be federal property. Sometimes the feds and states work together, like the Oklahoma City bombing, and you kind of get the idea. And espionage, spying, military crimes, all of the crimes that Congress passes have to fall under one of these 5 powers here. So very important to keep in mind, or somewhere else in the Constitution. The point is, I can't stress this enough, and that's why I've spent a few minutes on it. I can't stress enough how important that is. That's a major, huge, critical difference. Unlike all of this, state of California, we have general police power, which means the state could do whatever it wants. If the state wants to pass, the state can pass any criminal law it wants to. The state of California and the other 50 states, the only restrictions are contained where? What are the only restrictions on the state of California passing a new law against a crime?
Against the Bill of Rights.
Yeah, it can't go against the United States Constitution Bill of Rights. Like, we can't make a crime. We can make a crime, for instance, dealing strictly with the military. I don't mean military property, but trying to tell, say, military people what to do. Like making insubordination of National Guard a crime. That's a federal issue. That's preempted. But the Bill of Rights might be a restriction. What's another restriction on this? And that's not a big one. Bill of Rights goes more to the process of how we find people guilty of the crimes, but you're right. What's another restriction on the states? So Miranda, you know, that's a Bill of Rights issue. What's another restriction on the states? Passing a new criminal law. As wacky as it is, it could be about just about anything besides the Bill of Rights. Anybody? What was Prop 8 a hint? What was Prop 8 all about? Anybody know Prop 8, the gay marriage issue? What's it all about? What law did it change? The voters voted on this. Yeah, and good. And where is the ban? They voted to change a specific document.
That marriage has to be between a man and a woman.
Right, and where do they put that law? Right, they put it in the state constitution. We've had that for about 15, 20 years, but it is in our family code, whatever the code is that deals with domestic relations. But Prop 8 dealt with putting it in the state constitution. Likewise, we cannot write, our legislature in Sacramento can't write a criminal law if it contravenes our own state constitution. We don't care what any other state does, but we can't do that. So critical distinction. And we'll be going a little faster here.
I was going to let you know, I
Go
don't
ahead.
know if you know, but federal got involved with the bombing incident.
Did they?
Yeah, FBI showed up to do this.
They did, and depending upon what they find. And one of your classmates mentioned in the Colorado Redwoods bombing last week, the feds got involved. Why might they want to take the case? Even though Humboldt County, Paul Gallegos is perfectly within his rights, it's against the law in California to make bomb threats, has been for years. Why would the feds maybe take the case if they chose to? What would be a practical reason why they may take it?
Because in school, they're college students.
Okay, and what's the basis? Well,
National security.
maybe, yeah, national security. Also, federal student financial aid. We get a lot of federal grants in this institution, and that places us somewhat under the purview if they choose. But under a more practical level, why would the feds take the case? And not, why would Paul Gallegos, if he develops a case, why would our local district attorney hand it over to the feds, even though he can prosecute it if he wants to? What's a very practical reason? Think about it. Because oftentimes a lot of crimes both the states and feds can prosecute. Why do the feds often sometimes take a case? Like the bank robbery cases. Those are against state law, you know, to rob somebody, whether it's in a bank or elsewhere, who cares? Robbery is robbery. So why is it the feds often take these cases? Yeah, the resources, the feds not only have a much higher level of punishment typically than the states, but they have far more resources than state government or local county supervisors have to spend on prosecuting cases. So that's a very practical reason why a lot of times, like bank robberies, and especially a case if bombing, if it turns out that they can develop evidence to prosecute for the bomb threat, why it might go to the feds. So, as I said, lower courts have limited jurisdiction, and let's talk about this briefly. This is different from the slide we just handled a little bit ago. Simply put, when the Supreme Court makes a decision whether a law is constitutional, that binds the whole United States. Simple enough. When our local district court, federal district court in Sacramento, and you recall from maybe earlier discussions, certainly those of you in poli-sci, we have a federal court system in the United States. If the United States District Court from the District of Northern District of California, if they say make a search and seizure ruling on the use of drug-sniffing dogs, that ruling on drug-sniffing dogs only affects the Northern District of California. The Southern District, Wyoming, Florida, Mississippi, Montana, and the same type of issue are not obligated to follow that decision. So district courts only bind the geographic area where they sit. Courts of appeal, if the Ninth Circuit Court of Appeals, for instance, makes a decision, and I believe in the gay marriage issue, I believe they held that the gay marriage is unconstitutional. I believe the Ninth Circuit in San Francisco, if that was a criminal statute, we'll just say it's some sort of a criminal statute, that only applies to the states and the Ninth U.S. Circuit Court of Appeals. So other circuits have held the gay marriage ban is constitutional. That's exactly why the United States Supreme Court is taking up the issue. It's, number one, a great issue, an issue of huge public importance and significance, because whether or not homosexual marriages are recognized by the states creates some significant policy issues for all 50 states. And secondly, different federal courts have made different decisions. So the United States Supreme Court has to be the referee and make a ruling that covers the entire United States. Constitutional challenges, no federal law. These are pretty much the same, and I think I talked about this a bit earlier. These are due process concerns. So just like states cannot write laws that are so vague, And some of you from there, anybody recall what PC 415 is? What's PC 415? Yeah, disorderly conduct. You've no doubt had to deal with that in your capacities, booking in the jail. 415, 415, 415. So, what does making unreasonable noise mean? Does that sound like vague and overbreadth? It sounds pretty vague. Well, our disorderly conduct statute has had to be fine-tuned over the years because people have successfully challenged it as saying it's vague. How can the ordinary person know what the law means, making unreasonable noise? It sounds like it gives the cops almost total discretion to cite you or not. If fighting in public is fairly easy, but unreasonable noise or loud or threatening words or obscene language, that's kind of tough. So the federal government, the point in all this, is bound by the same restrictions as the states. They cannot pass laws that are so vague that the ordinary person can't understand them. They cannot, under ex post facto laws, they cannot punish behavior that happened years ago. So if they pass a new law, say possession of unauthorized possession of car keys, let's say, I'm just making up an example, and you had car keys that didn't belong to you, and they made a special statute saying it's against the law to possess car keys, simple possession, just the keys that don't belong to you. If it was legal for you to possess those car keys on January 1st, and the legislature passes a law saying on July 9th, it's illegal to possess car keys, and they make it retroactive to January 1st, that would be illegal. That's punishing conduct that was legal when it occurred, which is why a lot of times, if you, and I mentioned this cold case, this kid in Mississippi who got killed, this young black man that got killed. The way the case has to be tried under some rules that occurred 40 or 50 years ago, because ex post facto doesn't let you punish a defendant greater in the present day than when the law was originally written if you're prosecuting somebody under an old law. And of course the Bill of Rights applies freedom of speech and religion every bit as much to the feds as it does to the states. So here's a similarity. To find culpability, the prosecutor has to show both a criminal act and criminal mind or intent for most crimes. There are a number of strict liability crimes. And if you recall, well, what are strict liability crimes? What's the simplest definition? Mr. Krela, what's a strict liability crime? This may be on the third exam.
Third exam?
Possibly.
I haven't done third exam yet, so I don't know.
We covered this.
Did we?
Well, where have you been? We've covered this 12, 13 weeks ago.
Oh, slip my mind.
Imagine that. Mr. Mendes, what's a strict liability crime? What's that? Mr. Nova.
I'll take it. Straight liability is, it doesn't matter whether or not they meant to do it. All that matters is that they did do it.
Right, the act. You committed an act, you're guilty. Simply put, good. Yeah, kind of, Mr. Rico. The law is the law. You commit an act, we don't care why you did it. What's an example? You can redeem yourself, Mr. Creel. Give me one example of a strict liability crime. Now that you've been given the definition. You do the act, that's the crime. We don't care why you did it, you did it. And that's all that matters. First degree murder is not a strict liability offense. They have to prove premeditation. Give me one example of a strict liability crime where you do the act, you're guilty. We don't care why you did it. And you deal with this in the jail every day you live. Yeah, good, DUI. You've redeemed yourself.
Sorry to slip that.
Yes, you shouldn't have slept through that. Anyways, strict liability would be like most traffic offenses, drunk driving. Cop doesn't care why you had 0.20 blood alcohol. The fact is you had it when you were stopped. Arson. Yeah, arson, child pornography is a good example. Arson, common law arson, that's fairly true. Although that's in between. I like the child porn example much better. Mere possession is a crime. We don't care why you had it. Parties to crimes. Major difference here. Unlike California, essentially, federal law has no difference between principal successors. if you had knowledge of criminal activity of wrongdoing and you in any way participated, aided, abetted in the planning or commission of the crime with overt acts, one or more overt acts, aiding and abetting means you're guilty as a principal. In fact, they really don't use the word principal at all in federal criminal statutes for the most part. So anyone who commits an offense, aids, abets, counsels, commands, induces, or procures its commission, as well as the person who does it, is punished as a principal. So federal bank robbery statutes, for instance, and I've used bank robbery as an example throughout the semester because it's a good illustration. We lump everybody who had any meaningful part in the crime. The sole example, or it's the sole difference with that would be accessory after the fact. The federal government does have a very specific crime of accessory after the fact, and it's usually couched in something like harboring a fugitive. It is considered a completely separate crime, but like most crimes, it does require an act. It does require act and intent, an intent and an act. The act might be hiding, say, the money. Somebody just pulled off a robbery somewhere, accessory after the fact, and you know this person who comes to your house, let's say they're a friend, and they didn't talk to you about the job they're going to pull, but they bring you $20,000 and you know they're poor as church mice. They have to say, I got to leave. Can you just hide this under the floorboards? That looks like that would be a good case of the accessory of after the fact. But unless you have some sort of a past which would lead a jury to infer you knew what was going on, the feds or states that have the statute, they've got to prove some knowledge on your part that you knew this illegal criminal activity. Merely because somebody asks you to hide something, it's probably pretty obvious to us that it's a crime. But unless they can prove some way, let's say you knew this guy's criminal past, and maybe you were involved in some prior activities with him of a criminal nature, juries would need to hear that before you could be found guilty of a crime like that. Merely that something looks suspicious doesn't necessarily, in and of itself, always make a person guilty. Capacity and defenses. Much of the same law of capacity defenses, that is age, self-defense, insanity, entrapment. Many of those defenses, affirmative or otherwise, that we talked about earlier, duress, mistake, necessity, also apply at the federal level. There are some differences, however. I want to start with infancy. Infancy, meaning juveniles, that is under the age of 18. The United States has a general policy that federal courts don't typically try kids. Why is that? Why is it feds, even though juveniles can commit crimes with the best of us, why is it suppose federal courts have more or less a hands-off policy with kids? Anybody? Why is it feds don't get involved much with juvenile crime? Anybody out there in cyberspace? What do you think? Well, I don't know if it looks bad. Well, it looks bad in state courts, I suppose, if a kid goes, but federal courts can try juvenile cases. Anybody else? Anybody want to give it a shot out there? Why do they generally defer to the states? Because any crime juveniles commit are basically, for the most part, violations of state law as well, as we talked about. Like they catch the kid rifling through postal boxes at the Clark Street post office. If they catch a kid, say, a 16-year-old's a prank vandalizing the mailboxes in there, the feds are going to want to get involved in that, but it's likely not going to go to federal court. States have plenty of laws regarding minors. Well, the feds do too, but why is it you suppose the federal courts don't take those cases? One more shot at it in cyberspace there. As somebody is typing furiously here, I hope.
Wasn't it usually safe for juvenile cases about not about punishment, it's about rehabilitation? So maybe the federal courts aren't about rehabilitation; they want to focus on it.
Yeah, I think you've got something. Mr. Krela has an interesting point that juvie courts are all about rehabilitation. I mean, that's the general philosophy in the United States. And even though federal courts, through probation, parole, much like at the state level, deal with rehabilitation, the feds just have had a general policy for decades now that dealing with kids, state courts, even in small states like Arkansas or Wyoming or wherever, are better equipped to handle juvenile cases. They're best left to the states. You know, if you're charged, let's say Mr. Nova's picked up with some federal charge, he might do, if he's convicted, say, of a doping charge, and you've lived all your life in the Eureka area, you might get shipped off to some prison in Podunk, Iowa to do your time. That doesn't exactly help much with kids, separating them far from their families. So for practical reasons like that, not expense, practical reasons, the feds feel it's best that those cases are handled by those states and communities rather than hauling them in the federal system. It's really just more a policy decision, and one of the few instances that the federal government's displaying some common sense here. Although the feds, if it's a violation of the law, it's a violation of federal law, they would have every right to handle the juvenile cases. Mental impairment, insanity defense. All I'm really going to say here, folks, is unlike many states, you recall earlier when we talked about insanity, about the fourth or fifth week of class, or maybe a little earlier. If the defendant wants to bring on an insanity defense, what do they have to do? What are some of the things they have to do before a defendant can claim insanity? Your Honor, I'm not guilty of this homicide. I was insane at the time. What do they have to do once they're charged with a murder, for instance? What does any defendant, say, in California have to do? What's that? Yeah, good. Number one, good. They have to notify the prosecutor. They also have to put on before the court at a jury trial or pretrial hearing. They've got to put on sufficient evidence, either pretrial or at the trial, by a doctor, a medical professional, or other people who can establish some evidence of insanity at the time of the trial. The nature of the way the murder is carried out, maybe the defendant has a past record, something of this nature. The point is, this is an affirmative defense, and in state court, if I'm, say, defending Mr. Nova on a murder case and he's claiming insanity, I've looked at the police file, I know something about his past, I've talked to his doctor, he's maybe severely bipolar, he's got some other issues. After you get through these classes, maybe you will be your AJ degree in 4 years. Anyways, I only have to prove by a preponderance of the evidence to the jury. At the jury trial, I put on Mr. Nova's doctor. I put on witnesses who know him, maybe can testify to his erratic behavior near the time of the murder. I produce the school records. I have a school psychologist maybe testify. He had some major problems in school. I only have to convince the jury and the judge that it's more likely than not he might be insane. The federal standard is quite different. The federal standard, I have to prove by clear and convincing evidence. I have a much higher standard to prove insanity. You remember, preponderance of the evidence is roughly, I think I have it on the next slide here, let's see. Yeah, preponderance of the evidence is anything over 50%. It's more likely or not that Mr. Nova is insane. I hope everybody out there is following me. So in California court, I only have to prove to a jury it's more likely than not that Mr. Nova was insane when he committed this crime. Then the prosecutor, you recall, the burden of proof, the burden of production of evidence shifts back to the prosecutor. He's got to prove beyond a reasonable doubt you were sane and therefore guilty of the murder. The federal system makes it harder for criminal defendants because what I have to do if he was charged in federal court and I was defending him, I would have to have enough evidence to convince the jury by clear and convincing evidence. So instead of over 50% probability he's insane, it would be something like 60 to 70%. It's a much higher standard. It's not beyond a reasonable doubt. Because some of you may remember our past discussion, you can't ever, remember the state always has the burden of proving guilt. You cannot do anything that shifts the burden of proving guilt beyond a reasonable doubt to the defendant. And if the government made me prove to the jury that Mr. Nova was insane beyond a reasonable doubt, that would have the equivalent effect of my having to prove his innocence. And that's not permitted. That's unconstitutional by the Supreme Court. So preponderance, this level of standard, clear and convincing, is a much higher standard. It's the same standard we use sometimes If you have a family member, say, that dies with a will and somebody contests the will, in some states to prove up a will that's a legitimate will, you have to prove it by clear and convincing evidence. There are some civil cases where we make the one who's making an assertion prove it more than just by a preponderance standard. Competency to stand trial, it's the same issue as in the state courts. I merely have to prove, if the issue with Mr. Nova, I'll pick on him for just a little bit longer. If the issue with Mr. Nova is not that he was insane when he committed the murder, but that at the time of trial when he's been arrested, he has to go through a grand jury, that he is incompetent to stand trial because he doesn't know what the heck is going on, I would have to prove to a judge that he's incompetent to stand trial. I would put on some of these same experts. The government would be entitled, and they would, to have an expert examine at their own expense on Mr. Nova. I would have my witness come on and talk about competency, or my witnesses. A judge would have to make a decision. The judge would only need to be convinced to a preponderance standard of the evidence, not beyond reasonable doubt. And once Mr. Nova is restored to competency, if ever, he could well be tried for the case. Let's talk just really briefly about entrapment here. I don't want to spend too much time. So entrapment is a situation where the cops set up drug stings or other activities, get people to get involved. I think I gave you the example of myself when I was a kid. I was at a summer camp and a swim meet or whatever at a pool. I almost had, let's just shall we say, to keep this clean, an involuntary gastrointestinal reflex. When I reached in, when I was changing my clothes along with everybody else in the boys' locker room, I saw a wallet sitting in the locker. It's just sitting there. I'll take it over to the coach there, the camp counselor, Jim or whatever his name was. Look what I found. And then instantly 10 cops or 3 or 4 cops, plainclothes cops, swooped out on me. Well, apparently they've had a rash of thefts and break-ins in the locker room. That's where I had my involuntary gastrointestinal reflex here. It was not pretty. Well, not literally. But in any event, I might, if they hauled me into juvenile court, maybe I could claim entrapment because I had no predisposition to steal. The point is, police sometimes set up operations, as you all know, to get criminals to come out in the open and try and deter and eliminate criminal activity or reduce it. So, entrapment, the same general rules follow under state law. It is an affirmative defense like it is under state law. And the important issue in entrapment is almost always predisposition. If the defendant, like we said earlier when we discussed the Jacobson case under that chapter that dealt with these types of crimes, if the defendant isn't already predisposed to commit the crime, then they've made out a case, a defense of entrapment. If the defendant was predisposed to commit the crime and did it, of course, and the police merely gave him the opportunity, that defense won't work. Guilty is charged. And so how do we go, if I'm defending, say, Mr. Mendes, he's claiming entrapment for a drug deal. How do I go about trying to convince the jury that he was entrapped, or the judge and jury that he was entrapped? What types of evidence, affirmative evidence, am I going to have to bring in to support Mr. Mendes' contention that the cops goaded him or forced him into doing this? Predisposition. How do I show that Mr. Mendes wasn't predisposed to commit this drug crime? Yeah, or lack of a criminal record. What else? What else might I use to show that he is not exactly upstanding, he's not a druggie at least? Maybe I'd have people testify. I'd have some people testify as to his overall reputation, that he hasn't been involved in drug activity. Not that he's a choir boy necessarily, but the point is drug crimes and drug activities and criminality in general isn't his thing. So it would become more of a positive thing. And this is what they're getting at here, entrapment by estoppel. That means in situations like this is a form of the defense. If the government tells you that this act is legal and you rely on it, the reliance is reasonable, then prosecution might be unfair. It's sort of a different form of the entrapment defense. I mean, defending, claiming entrapment. That is, if a reasonable person was asked to do something by the cops and they were told it's illegal activity, an example escapes me right now, but let's say the cops were trying to get a crime, or let's say they just flat out didn't like you. And they told you, yeah, you should try this. It's perfectly legal. Maybe it's some sort of a new type of drug or something. Try this. It's perfectly okay. And you do it. And the reliance objectively was reasonable. A reasonable person in Mr. Mendy's case was fine. That's kind of reasonable, rely on what the cop said. After all, he's a cop. Cops aren't supposed to encourage you to do illegal things. Then if the jury finds that your reliance is reasonable, then you've made out the defense of entrapment. But I can't think of an example right now. Yeah.
As far as like entrapment goes, I know the PD does this with DUI checkpoints to prevent people saying, entrapment and stuff like that. When it's set up in a block area, there has to be a turnoff before and a turnoff on either side.
Right, because you can avoid it.
Yeah, and it's like that's kind of. I asked one, why do you guys do that? That we have to, or people can claim entrapment. So that's stupid. The whole point is to kind of go through the DUI checkpoint. And I don't know as far as have to, but they get to prevent.
I don't think they're not really correct. That's not really an entrapment offense, because there's one.
Or maybe I understand.
No. There's one normally have for one thing, predisposition usually supposes some level of intent, does it not? When you're predisposed to commit crime, it normally assumes either general intent or something very specific, like to burglarize, a specific intent, or just to steal, theft. DUI being a strict, they're looking for DUIs primarily, right? Being a strict liability offense, it's the mere doing of an act. It's nothing to do with whether you're predisposed. Even, I know alcoholism kind of comes in there. I'm not sure it's really entrapment per se. I think it's really, I'd have to look at the statute. It'd probably be time for me to look at it. But the United States Supreme Court specifically ruled, it's not that the cops want to provide you now, but the U.S. Supreme Court specifically required it. I don't know if they're providing you with an opportunity per se to commit crime. They're not really setting it up because you're committing the crime by being on the highway. It's merely a detection issue. When you go through the checkpoint, they're not enticing you to commit the crime because have you not committed it just by being on the road? You know what I mean?
Yeah.
Why do they have to notify the public within so many days that they're going to have a DUI?
Yeah, that's why you're going to tell everyone.
And they don't have the public do there on the radio. Or
because the Supreme Court of the United States required. It's a specific requirement. I'm going to look up the statute, the checkpoints. I really don't think it's an entrapment stuff, and so I'm going to look at it. Let me make a note.
I know it's easy to do that.
They all do.
DUIs on like golf course road where there's no turnoffs. Right there in front of the golf course, and see them there.
I'm just not really sure it's an entrapment issue. It may be just a matter of fairness, that is, which doesn't make sense to me because, you see, when you're on the highway, you surrender an expectation of privacy, a big one when you're on a public highway. And I never, that always bothered me. The big issue with the cops in checkpoints is part of that case is they have to treat everybody the same. In other words, they have to either do every car or every fifth car. They have to, and they would have to keep records. If they did every fifth car, they can't just random going through the checkpoint. They can't random, hey, you pull over. We want to check you. Because that's going to leave too much discretion to cops. That's going to look like selective law enforcement. But I'm not sure it's really an entrapment issue. I'm going to look that up. So if somebody thinks about it, remind me. And what I'll do next week, we'll discuss it a little bit next week at the beginning of class, because that's kind of an interesting issue. Conspiracy laws are fairly the same as they are under state law, and if you remember conspiracy, these are the basic elements. Two or more people conspire in an agreement to accomplish an unlawful purpose. The federal law is a bit stricter, but basically, for the most part, all that's required under state and federal law is that under conspiracy, one person knew of the wrongfulness of their act. They didn't have to be aware of the crime. Like, for instance, if somebody's charged with conspiracy to distribute cocaine, If they're involved in the packaging, manufacturing, or sale, and they're working with, say, one other person, even though they're not, let's say they're just driving the cocaine to another location, and let's say it's wrapped up in packages, this cocaine. I mean, it doesn't look obvious like it's drugs. It's wrapped up. It's not a huge quantity, like 3 pounds. Let's say it's about 5 or 6 ounces or less, a couple of ounces of cocaine. Still a lot. And let's say it's wrapped up, and this person doesn't know all the details, but let's say they're the boyfriend of one of the couriers or something like that. The government would have to prove they have some knowledge besides merely possessing. They could be charged, perhaps, and likely so with possession of the cocaine, but as far as conspiracy, they'd have to prove a relationship and some common agreement with one of the other co-conspirators to the transportation or sale or trafficking in the drugs. But the conspiracy statutes are very similar to state law. RICO. This relates to conspiracy statutes. Basically, RICO deals with money laundering type activities. Essentially, what RICO requires is some sort of a pattern. So, for instance, this is initially aimed at organized crime. How did organized crime, those of you've all watched movies and read about it, how did organized crime, like in the early days of mafia, first of all, how did they make their money? Alcohol, gambling, prostitution, until recently, I mean, from recent times, drugs, pornography, all sorts of stuff. That's how they made their money, okay, and they were cash-only business. It makes sense to me so far. What do they do with all the money? You can't exactly go downtown to Bank of America, USA, and say, you know, I got $100,000. I'd like to open an account. Here's $100,000 cash. That's a little funny. That doesn't quite work. I think the feds would be very interested. So, how do they hide these millions of dollars? Yeah, such as? Anybody here from New Jersey? Be easy in Jersey. It's all over the place. Pizza. Pizza comes to mind because of the Italian mafia, but I mean, it's a stretch. Trash collection. That's been a big one in times past. Waste. I've heard it, but I've never seen it. Waste Management is a huge nationwide corporation, trash hauling and disposal and stuff. Maybe that's where they put some of the bodies. How convenient. Waste Management, franchises like pizza, restaurants, all sorts of stuff, printing businesses, all sorts of legitimate enterprise, not necessarily retail, electronics. So the RICO statute was aimed at people who get money from illegal means like extortion, extortion, drugs, booze, pornography, murder for hire, all these things. And so when they invest those in using those prohibited activities, that is 2 or more people, and in 10 years' time, let me get to the next slide. They commit these crimes in furtherance of their activities. They have a list of these crimes the feds can prove a likelihood of twice in 10 years. That invokes the RICO statute. Mail and wire fraud, that is transferring money and assets. Securities fraud, bribery, sports bribery has been added recently. Counterfeiting, embezzlement, prostitution, drug violations. So this is really broad. So if the government proves that, then the penalties are really, really stiff. The issue of RICO prosecutions are 2. Number 1, there have to be 2 or more people in these activities. You can't bring a RICO prosecution without having at least 2 people involved. You can only charge one, but you have to show before the judge and jury that there's at least one other person involved. And they could be something like in Richard Nixon days, an unindicted co-conspirator. They simply weren't charged, but you would have to identify who that person is. So it has to be conspiracy-based. And number 2, you have to be able to prove 2 or more of any of these crimes have been committed in the last 10 years. It's not a one-time thing. Murder for hire is not RICO. Extorting somebody for political favors, one time only and with one person is not a RICO violation. And why do we even have these statutes? Simple, because again, it was aimed originally at organized crime, number one, and number two, the penalties for RICO violations are extremely severe. And let me give you an example here. I just finished a fascinating biography. Politics has always interested me. There's a guy by the name of Edwin Edwards. He was a former governor of Louisiana for 16 years on and off. Anybody from the South who knows anything about politics has likely heard of him. Anyways, after he left his fourth term as governor in about 2000, he was charged under these RICO statutes. You know, he'd been in and out of office. He's a licensed attorney. And Louisiana, during the time of his governorship, was starting with riverboat gaming and casinos, you know, New Orleans and other areas. He was charged with his son and about 4 or 5 other business associates. A gentleman by the name of Eddie DeBartolo. I don't know if anybody's heard the name, but if you've been in a shopping mall, maybe not in Eureka, but anywhere in the United States, you've probably been in a shopping mall owned by one of his companies, Mr. DeBartolo, well, Jr. now. Billionaires. Anyhow, Governor Edwards is accused of twisting the arms of the licensing agencies in Louisiana. In return, he got money. He supposedly got $500,000 in payoffs from the DeBartolos and other individuals wanting political favors. It is wanting a sports license. He's accused under the RICO statutes. I think it's New Orleans Saints football team. He had a lot to do with building the Superdome in New Orleans, and I think how long have the Saints been around? Wow. Like 50, 60 years or less? Well, he may have had something to do with getting them or forming the team or getting them. The 49ers were involved in this too, the San Francisco 49ers. But he had some dealings with them, and he was accused of using his office, the extortion statutes, mail and wire fraud and extortion. And you think, well, what's the big deal? He's out of office now. He's a lobbyist. A lot of ex-politicians are lobbyists. And if they have contacts in government, which a guy that served 16 years has a lot of contacts. Well, here's the rub of it. And he was kind of a crook, but then he really did a lot of things for a lot of people. And personally, there are a couple of rubs in all this that made it hard for him. And by the way, the end of the story was that he was convicted of, I think, under RICO had a lot to do with it. I think it was 79 counts. He got 10 years in prison. He was 75 when he went to prison. 75 years old. He served till about 83. And he's 85 now, married to his third or fourth wife. He now has a reality show, he and his wife. So if you look on your TV, if you look on the governor's mansion, if you do a Google search, you'll find Governor Edwards. He and his wife have this TV reality show. I don't know how long it's going to go. But I think, what's that? Maybe. But here's one problem. What do you suppose he dealt almost exclusively in cash? It's harder to trace, number one. When they raided his house after he left office, he moved to a swanky part of Baton Rouge. They raided his house and found nearly over $250,000 in cash in the safe. That looks a little suspicious to a jury. They recorded 5,000 hours of taped conversations at his home and office, the FBI. I mean, it was a 4-year investigation. I mean, this is a multi-million-dollar investigation. And as it turns out, you know, he was convicted along with his son, who did 7 years. He was convicted, and most of the statutes, the RICO statutes, which got him 10 years in prison, were the gambling ones and the extortion. That is, claiming that he demanded favors and money in order to help secure licenses, bribery, fraud, all sorts of stuff. But it's that money, I think, that did him in, all this cash. But yet he had a plausible defense because, you know, he got paid lobby fees. Oh, and he had one other quirk. He liked to gamble. And he gambled in Vegas. He frequently flew on the jets of some of his buddies, these corporate jets. And he sometimes in a year made as much as $800,000 to $1 million in gambling profits. But the funny thing is he reported this to the IRS. They were all reported. They had his tax returns, and his income for the most part was all reported. As also, he took gambling losses too. So that was part of the way he made his living while he was governor and otherwise. So interesting guy. You couldn't get away, well, he didn't get away with it, but that the public elected him for 4 terms while he was doing all this stuff. Says something for Louisiana. Homicide. Homicide, the federal code is pretty similar to most states. It retains, first degree, second degree murder. Felony murder concept is also retained in the homicide prosecutions. Involuntary manslaughter. So unlike, however, here's another difference. Unlike felony murder, in many states, if you don't commit the bank robbery under the felony murder doctrine, you may not be found guilty of first degree murder. You all remember felony murder is? Typically, if you actually commit a murder, if you attempt to commit a murder, in most states, like we'll pick on Bank of America, a robbery. Is a robbery an inherently dangerous felony?
Yeah.
Yes. And if you botch a robbery, you attempt to commit it, but say you're thwarted, and you're charged with attempted robbery, and in escaping you shoot somebody because you want them out of the way, and you want to hop in the car and speed off. In California law, you could be charged under felony murder rule, first degree murder. Did you kind of really premeditate this murder? You kind of shot him, or some accident or something went wrong. Yeah, you intended to kill him, but we just treat it as first degree murder. Under federal law, you actually have to have committed the robbery. If the robbery is the underlying offense of felony murder, you would have had to have a completed robbery. That is, you would have to have the cash or something in your possession. It depends upon the way the statute is worded. So the statute of felony murder, if it's attached to a robbery statute, attempted robbery wouldn't work. In the bank robbery, in their federal law, if you actually got the money, well and good felony murder and killed somebody. If you didn't get the money and that was attempted robbery, it's not felony murder. It's going to be some degree of murder, but it wouldn't be under the felony murder rules. Everybody with me?
Well, yeah. I remember reading something about the statute or something that if you have the intent to, like, you want to go out and shoot someone, and you go to shoot them, but you miss it, if the person behind you that you did not intend to shoot, what's that called?
Transferred intent doctrine.
Now, does that fall under federal, or is that?
The feds have it. What Mr. Creel is talking about, for those of you out there, folks, is that if you intend to shoot A but miss him and shoot B instead and kill B, that's called the transferred intent doctrine. That simply means you would initially be charged with intending to kill A, but A isn't dead, B is. The transferred intent doctrine, even though all the evidence shows at the trial you clearly intended to kill A, which you didn't. You missed him and killed B. The transferred intent doctrine holds you're still guilty of first degree murder because even though you intended A, you killed B. So we let you charge and convict somebody on premeditation, even though the person you premeditated against wasn't killed. Felony murder is similar, but it's really not the same. If you commit a certain type of violent felony like robbery or rape, and in so committing it, you kill somebody, either the rape victim or, say, a bystander in the robbery, you don't intend to kill, it's not the bank teller, but you kill somebody waiting in line. I remember in South Dakota, a little country bank was robbed. The 71-year-old granny who's making a deposit got killed. During the getaway, they pointed a sawed-off shotgun at the teller, and the teller complied, but something happened. I don't remember all the facts of the case, but when they went away, they killed the 71-year-old grandma who was just making a deposit, and they charged him under the felony murder rule, not transferred intent, with the murder. Under normal circumstances, if it was an accidental murder, it would be either second degree or voluntary manslaughter. But because in the felony murder rule it happened in the course of a dangerous felony, we don't care. It's first degree murder. And so there are 2 counts, the robbery and first degree murder. And we don't call it felony murder. We just simply, on our criminal complaint, felony murder. First degree murder. Assault and battery, not much difference. Again, notice there has to be some interstate commerce connection here, or some connection, all of these, with the federal government. Lindbergh Law, you all know about Bruno Hauptmann, the German immigrant who was accused of killing Charles Lindbergh. You also remember the Lindbergh case, the baby kidnapping?
Island?
Well, yeah, it was his son. You guys remember history? Okay, we should cover that in trials. That's actually one of the trials, but it wasn't really criminal procedure. What happened in 1932, you know, Charles Lindbergh, the Spirit of St. Louis, folks, he was this famous aviator that flew from, New York to Paris in record time in the Spirit of St. Louis, a single-motored plane. Anyhow, he settled down in New Jersey, and anyhow, he had an 18-month-old son who was kidnapped in 1932, and it didn't apply to him, but the state of New Jersey, of course, prosecuted him. Has any of you heard of Norman Schwarzkopf, the general? You ever hear of him? Oh, boy. You guys must be younger than I thought. The first Gulf War in 1991, he was this big, 300-pound gorilla, 4-star general in the Army. He just died a few years ago. His dad actually was the lead investigator in the Lindbergh case back in '32. Any event, Congress enacted the Lindbergh Law in 1932 in response to the killing of the baby. And anyhow, Bruno Hauptmann was executed in the electric chair in New Jersey. And evidence developed later that cast some serious doubt on whether or not he was guilty, but he was executed. So Congress, in response to Charles Lindbergh's baby being kidnapped, passed this law and says that if you cross state lines in the commission of a kidnapping, that's a federal crime. So again, there has to be an interstate commerce aspect to kidnapping. Otherwise, like in Lindbergh's case, the state would handle it. There has to be transportation of the individual, and that was murder and kidnapping, of course. There have to be these 4 elements. The one I want to focus on briefly is there has to be an interstate commerce element to the kidnapping. Unconsenting person. So, except for that first element, you'll notice, does that sound like kidnapping? Taking somebody, inveigling, decoying, holding somebody against their will, unconsenting person, held for ransom. Does that sound like regular kidnapping? It kind of does. But what makes this a federal crime is the first element. It has to be an interstate or foreign commerce for it to constitute a federal crime. Hate crimes. Hate crimes is an interesting situation, and let me talk about this real briefly, hate crime statutes. All hate crimes are really sentencing enhancements. In the federal system, rape, murder, robbery, arson, vandalism, the federal government does not take it unless the motivation for committing rape, murder, arson, violent type crimes, it's motivated by somebody being of a protected class, homosexual, a minority, handicapped, developmentally disabled. Is it a crime to murder, rape, pillage, rob? Of course it is. All 50 states have those laws. But Congress got into, do you remember the first couple of slides? I didn't talk about it much. There's some people that argue that we're federalizing too much crime, that we're dealing with a lot of crime that's best left to the states. Hate crimes is probably a very good example of that. Rape, murder, robbery, whether it's against or by a black person against a white person, doesn't really matter in that the states can prosecute this. Hate crimes were passed, Congress first passed the first hate crimes legislation about 20, 30 years ago because a lot of white on black violence in the South, as you might imagine, even until the 1970s and 80s was not being addressed by local authorities, and so Congress got in the act. The rub is there has to be something of an interstate commerce nexus to it, and that's what's sometimes difficult to prove. The courts have given some leeway to this. But see, federally protected activity, these are brought, the justification for many of these is under civil rights statutes. So just know, though, that hate crimes are essentially sentence enhancements because we punish people for murder, rape, robbery, vandalism, cross-burning on somebody's lawn. It's just when it's a hate crime, we up the punishment of it typically. Arson. Arson, again, notice there has to be interstate or foreign commerce involved. So if you're burning a federal facility like protesting and you torch a facility, fine. If you torch, say, trucks in transit, that is, if you, let's see, there's some trucking, what are those couple of trucking companies there, Costco? There's a couple of freight lines. Near Costco, yeah, in that part of town. Moving and storage. Yeah, UPS, FedEx, Humboldt Moving and Storage. If you torch their vehicles, how do we get that on? How can the feds prosecute torching the FedEx office and say they're trucks? I mean, the EPD usually in the fire department would be right on it. Paul Gallegos could prosecute. Why might the feds get involved?
Especially with UPS.
Interstate commerce. Yeah, all these trucking companies, interstate commerce. Arguably even Costco, because Costco is a multi-state company. So if you take and torch a Costco truck, if the feds chose to get involved in that, they would make a very plausible argument that you violated the federal arson statutes, because Costco trucks, and what would help the U.S. Attorney's case is if that truck was registered in another state, you know, the license tags from another state. So, and why is the feds often don't get involved in local instances like this? Simply because it's a matter, even though they have unlimited, what amounts to almost unlimited resources, the U.S. Attorney makes a considered decision that localized instances like that are best left to Paul Gallegos' office and or the state of California. Just because they can get involved, they don't. Oftentimes, there are similar considerations as we talked about earlier in juvenile justice. It makes sense better for the states to get involved. Burglary. Again, an interstate commerce aspect here, foreign shipments. So the pipelines, you know, there's been some hostility towards the Keystone Pipeline, or, you know, environmentalists. If they were to try and attack or destroy a pipeline, that would be, that might conceivably be burglary or pipeline system. So you think of burglary as breaking a car, truck, or trailer, or occupied structure. Well, burglary in the federal sense, if you break a pipeline besides vandalism, would be considered burglary. Breaking an oil or gas pipeline. Clearly interstate commerce there. Robbery. Question 14 deals with these next slides. Discussion question 14, so please please pay close attention to these. Big difference. And the question asks you, what are some of the big differences between the elements of robbery and under state law or common law and robbery under federal law? And here's the difference. In common law, you basically have to have some sort of a taking. Remember, you have to take or attempt to take the property. In common law, in federal bank robbery, you don't have to actually take and carry away the property. You don't have to move it at all under bank robbery statutes. If they plop the money on the counter under federal bank robbery statutes and you don't get a chance to grab it because you're intercepted, the crime of robbery has already been committed because you've exercised some dominion of control. Even though under common law, remember under common law you had to move the property some distance? Under federal law, you don't have to do that under specifically bank robbery statutes. If they get the money and put it in a bag, but you don't have a chance to grab it because say some alarm goes off, not considered robbery. These are the basic elements. So in the interest of a little time, I'll skip through this. Obtaining property by false pretenses. A lot of these crimes are used for telemarketing schemes. These types of statutes are the ones feds use to go after. Is anybody here taking criminology? This semester? Not this semester, criminology. 5. Yeah. You took it a couple years ago. Do you remember watching the movie? I show up sometimes, Con Artists, telemarketer. There's a guy who sold a coin. He was on the phone.
He's a good talker too.
Yeah, he was. Remember they had him seal it? Yeah. Those of you out there in cyberspace, in criminology, I showed a short 50-minute documentary. It's called Inside the Criminal Mind, Con Artists. And one of them was a telemarketer who, by his own admission, gave a guy 27 times to refuse to buy a $3,000 gold coin. What did the guy do? He finally got his credit card number, gave it to the guy, who immediately got it out of his account and got $3,000 bucks. And of course, it was a pure scam. So telemarketing schemes typically are prosecuted by the feds. Clearly, interstate commerce, once you use the phone, that's interstate commerce, whether it's in the same state or not. And mail or wire fraud, it's these particular offenses that the government prosecutes, obtaining property by false pretenses. But again, there has to be an interstate commerce aspect to it. Forgery, fairly self-explanatory here. So I'll let you kind of read that on your own. Again, has elements of counterfeiting, deals with United States securities, money, coinage, things like that. This is one that's common for RICO prosecutions, tax evasion and money laundering. Can anybody tell me the difference between tax evasion and tax avoidance? It's actually an important distinction to make before we leave. What's the difference between the two? One's criminal and one isn't.
Tax evasion is criminal.
Why is it criminal? Or what is evasion?
You're doing it on purpose. You're lying.
Doing what?
Not reporting taxes or income.
Evading the payment of taxes, yeah. In fact, the tax statutes, Al Capone was never hung on murder charges by the feds. You know how they got him? They got him on tax fraud. Because the Internal Revenue Code says all income is taxable from whatever source derived, illegal or not. It's taxable income. So what's tax avoidance? That's perfectly legal. What's tax avoidance? And sometimes there's a mighty fine line, but it's perfectly legal. What is it? What's an example of tax avoidance? Think about it. How can you avoid paying? What can you do to minimize your tax liability? What's that?
Just like if you go to Oregon, so you want to pay taxes, Oregon.
No, you live here, and let's say you're eventually going to work as a cop, and you do overtime, and you're 3%, not anymore, but you work 3% at 50, and you make with overtime $100,000 a year, and you're single. What do you do with all that money? Some of it, anyway. You want to save some of it, right? I mean, you don't want to spend it all at once, of course, but how do you get involved in tax avoidance? I mean, I do it all the time. What are ways you can legally reduce your tax liability and staying put? You know, you stay right here. You're not moving to a state that has a lower tax rate.
Like somebody with
So I thought you said strict and generous. Good. Strict and serious penalties. Yeah, legal methods and what good? What IRAs? Good. You folks out there, excellent. So if you get an IRA, a 403 plan, for instance, myself, what I do is so much money I have every paycheck is diverted to an IRA. So my tax bill, I reduce it every year by about $700 or $800 or $1,000 a year, because some of the money the college sends to a retirement plan, you know, on top of the pension that I would normally earn. And California pensions, they're not taxable until they start paying them out to you. So, yeah, donations to charity, I do that too. And not that I would like to be charitable, but frankly, when I make donations to charity, the first thing I want at the beginning of the next year, when I have to start putting taxes together, I need the form from you that says how much I gave, because I can't claim deductions unless I have documents to back it up. So we are done, folks. A few minutes early. We will see you next week for the final class and some important announcements. So have a great week. Glad to be back. What? We have got one more class next week. Don't look so disappointed, Mr. Freeland. I can tell. Yeah, the waterworks is. What's that?
I'm still going to see you.
Yeah, I just don't want to. I don't want any parking tickets, so that's all.
I'll see you
No.
tomorrow.
I know. I got my one parking ticket from Sierra and learned my lesson. And here I parked just on the other side of the no parking sign on Tompkins Hill Road. See you guys next week. I'll stick around, folks, for